Shalom, this is Yahuah Magnified, and I'm back with another informative video. Today's video is titled Parental Privilege. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, let's get to it. Oh yeah, but before I start, be sure to hit that like button, okay? Because I'm trying to change the algorithm. As you all know, YouTube has in fact shadow banning my channel, so a lot of people are not getting this information. So in order for this information to get out, hit that like button so more people can view and understand what's really going on, okay? So I'm doing this video pertaining to CPS. So for those who are dealing with child protective services for disciplining your children, this video is for you, okay? And hopefully this video can stop someone else who in the near future who may be dealing with child protective services to get their children back, okay? So now, let's pick this up from the top where it states parental privilege doctrine, law, and legal definition. It states, parental privilege doctrine refers to legal principles granting parents the right to bring up children free of government interference, okay? So you have the right to bring up your seed free of government interference. Okay, but let's continue. A parent has the right to discipline his or her child reasonably and to exercise decision-making authority over the child without interference from the state. You hear that, guys? So you guys actually have the right to bring up your child and support your child and discipline your child without the interference of the state. But let's continue. The state cannot interfere with this right, which is guaranteed under the United States Constitution Amendment 14, unless the child's health and welfare are jeopardized by the parent's decision. Okay, so we're going to go over this case real quick that happened in Virginia. I think it happened yesterday, as a matter of fact, where a parent who disciplined their child was incarcerated, and then for spanking her children with a belt. Okay, and that case got overturned because of parental privileges that she had to do so. So without further ado, let's go to the case law so we get better understanding of what's going on. Let's read the case so we can see how you all can apply it for those who are dealing with CPS. Let's go there. Okay, so now let's go over the article so we get better understanding of what has taken place. It states, VA appeals court overturns belt discipline convictions saying parental privileges usurp. Let's pick this up at the top where it states Virginia's. Right there. It says Virginia's Court of Appeals has overturned the convictions of a mother found guilty of assault and battery for disciplining her 12-year-old twins with a belt. After the panel said the trial judge overstepped her authority in suggesting she should have chosen a different punishment. So again, like in this case and in most cases, the trial court judge always, in most cases, overstepped their authority. But if you don't have understanding of the rules or what's going on, then they will continue to do these things. But let's continue on. It states, Virginia, like every other state, permits parents to discipline their children with corporal punishment, okay? So let's hold right here and let's find out what in fact is corporal punishment. Let's go there. Okay, so now we're going to pick this up where it states corporal punishment. It states physical punishment as distinguished from pecuniary punishment or a fine. Any kind of punishment of or inflicted on the body, such as a whipping or the pillory. The term may or may not include imprisonment according to the context, right? So again, corporal punishment is any type of punishment that's basically done or inflicted on the body, okay? So the key word is corporal. Now let's find out what corporal is. Corporal, relating to the body, bodily, okay? So if corporal relating to the body, like I tell you guys, when you're going to the court, you're going in as a dead entity. That's why they're using the term as corporal, which is also another term for corpse, which is strictly what it is, relating to the body. So when you're going in there as a corporal or corporation, then it means that your body is going in or you're stepping into the court as a dead entity and or corporation, which is in fact still a dead entity. That's why corporal punishment applies when you're dealing with children, which is also a creation of the state, which is also a fictitious entity, aka a business. But let's continue on. Okay, guys, so let's pick this up at the top where it states Virginia, right here. I'm not going to read the whole article. I just want to give you all, short bits and pieces of the article. When you all get time, you can simply do your research, to study to show that ourselves approve. But let's continue. It states what? Virginia, like every other state, permits parents to discipline their children with corporal punishment, wrote the 3-judge panel in an opinion published Tuesday. This parental privilege excuses what would otherwise be battery in the ordinary course. To fall within the parental privilege justification, discipline must be reasonable and not excessive, according to the opinion. Tina Dion Woodson was convicted in Hanover County of assault and battery after disciplining her 12-year-old twins with a belt. While each child had a minor bruise or a mark afterwards, neither was seriously injured. While the appeals court had considered cases in which a child's injuries were severe, this was the first time the panel considered whether the combination of other facts was enough for criminal liability to result. The children were disciplined for using a cell phone outside of hours established by Woodson and her husband. A mutual friend had texted the twins. Let's continue. According to the opinion, Woodson asked her son to get a belt from her closet and told the twins to lay on the bed. She then hit them with the non-buckle end of the belt. Later that day, the son told a school resource officer he didn't feel safe going home. When the daughter was asked by resource officers, she expressed a similar fear. The investigator testified that she saw bruises and marks consistent with a belt strap on daughter's back and thighs when she spoke to daughter that day, wrote the appeals panel. Woodson testified and denied using corporal punishment that day, but argued the evidence established as permissible spankings and not excessive discipline. Judge Jane Brody found Woodson guilty, saying the testimony of the son and the daughters was very credible. Right? So now let's continue to what the appeals case says. The appeal, while intentional touching qualifies as battery unless the person doing the touching has some legal justification or excuse, the presence of an accepted justification or excuse transforms what otherwise be a crime into a permissible act, the opinion said. Woodson argued her convictions for assault and battery should be reversed because her actions constitute a reasonable corporal punishment falling within parental privilege. The Court of Appeal said a parent has the privilege to discipline his or her child within the bonds of moderation and reason. So again, guys, you all can see basically what they're doing is taking a right and turning it into a privilege. But let's continue. According to the court, the privilege protects diverse parenting values and practices, while also limiting the sufficient cause on a family that can come from government intervention. Alright guys, so remember yesterday I was talking about how hard it is, especially for being a black family, dealing with these court systems and things like that. So now let's read this important paragraph. This paragraph is very important. Let's pick this up at the top. In this way, the privilege generally serves the well-being of children, reflecting a trade-off between protecting children from the harm a parent may inflict and the harm that comes from unnecessary state interference. Okay, guys? So remember, the state can cause more harm as well once the state interferes in your family life. But let's continue. Criminal proceedings may lead to incarceration or invasive community supervision, and criminal intervention initiated by the child welfare system may lead to remove the child from the home. So you'll know once they remove the child, that's going to inflict more pain and more harm to the situation. But let's continue. In this way, difference to parents provides a particular important shield for low-income families and families of color who disproportionately experience state intervention. So again, guys, as we all see that people of color experience this more than any other nationality of people, okay? So understand this, guys, all right? So let's continue on. States, the court considered the severities of injuries and risk to the children. Quote, sufficient physical harm is best understood as involving injuries that are evidenced by something more than mere transient pain or minor temporary marks, the court wrote. And the punishment was not administered in a fit of anger, since corporal punishment cannot be used as a cloak for the exercise of mild violence. So again, guys, this one paragraph alone is extremely powerful and can be used in your case to help you all get the evidence that you need to get your children back for those who simply discipline their child and someone called Child Protective Services on them, and trying to make it seem as though they are unfit or whatever the case may be. But let's continue. In its conclusion, the Court of Appeals ruled the trial judge characterized what occurred as a mere texting violation and suggested Woodson should have made a different parenting decision by taking away the phone or restricting phone privileges. But let's continue. Parenting is an inordinately difficult task, and a criminal prosecution cannot rest on a debatable parenting decision without other evidence that the conduct was excessive, wrote the appeals court. Disagreement with Woodson's decision to use corporal punishment combined with evidence of only transient marks from the soft end of a belt falls short of what a reasonable fact finder can conclude is excessive. The court said the evidence created only a suspicion of probability of guilt and fell short of the legal standard of beyond a reasonable doubt. The convictions were dismissed. So again, guys, with that being said, for those who are dealing with CPS, all because you simply disciplined your child, you have the right to discipline your seed, okay? But like I told you all before, they're not referring to your seed. They're referring to the state-created birth certificate, okay? That is the child, okay? We just attach our seed to the documents. That's why it's called the body attachment. But as you all can see, that they consider the body to be corporal. Why? Because the body is in fact a corporation. All right, they can only deal with dead fictional entities, as I told you before. That's why it's called, when you discipline a child, corporal punishment. All right, so you all have a right to inflict corporal punishment on your seed when they're not acting right and they're being disobedient. Okay, don't let anyone tell you all different. So for those who are dealing with CPS, this is more facts, more truth, and more proof you can use in your case to get your case overthrown. All right, so with that being said, like, share, subscribe. That's all I'm going to do for today. If you all need my help, hit me up in my email at yahuah@gmail.com. Cop that merch, guys. Cop that merch. So with that being said, I say shalom.